majority have passed through multiple other safe countries and in some instances have resided in safe countries for several years. There is a strong argument that they should cease to be treated as refugees during their onward movement. There are also many whose journeys originate from countries that the public would consider to be manifestly safe, like Turkey or Albania or India. In these instances, most are simply economic migrants, gaming the asylum system to their advantage. In Europe, we've added, through the European Convention on Human Rights, additional human rights laws. The global asylum framework is a promissory note that the West cannot fulfill. We have created a system of almost infinite supply, incentivizing millions of people to try their luck, knowing full well that we have no capacity to meet more than a fraction of the demand. Tragically, the ease with which this system can be gained by those that don't really need it means it is the most vulnerable, women, children, those without the money to pay people smugglers, and those not fit enough to make arduous journeys that lose out. In the UK, roughly 70% of those arriving illegally on small boat are men aged under 40. This is a hypocritical position for the West to maintain, and by creating a market for people smuggling, it is leading to considerable human suffering. So why has the international community so far collectively failed to explore any serious reform of the global asylum framework? I think there are two main reasons. The first is simply that it's very hard to renegotiate these instruments. If you think getting 27 EU member states to agree is difficult, try getting agreement at the United Nations. The second is much more cynical. The fear of being branded a racist or illiberal. Any attempt to reform the Refugee Convention will see you smeared as anti-refugee. Similar epithets are hurled at anyone who suggests reform of the ECHR or its court in Strasbourg. I reject the notion that a country cannot be expected to respect human rights if it is not signed up to an international human rights organisation. As if the UK doesn't have a proud history of human rights dating back to Magna Carta, and the ECHR is all that is holding us back from becoming Russia. America, Canada, New Zealand, and Japan seem to manage just fine. None of this is particularly novel, nor should it be particularly controversial. As Home Secretary, Theresa May called for Britain to leave the ECHR, and it was Conservative Party policy under Michael Howard to leave the Refugee Convention. I'm merely advocating for reform. Now, while the underlying framework is both a contributing factor to the problem and a barrier to certain fixes, some countries have been more successful in tackling illegal migration than others. Australia had to cope with two major waves of illegal maritime migration across the Pacific in the last 2 decades. In the last wave, before they stopped the crossings, more than 52,000 unauthorised maritime arrivals and around 1,100 deaths at sea were recorded between 2008 and 2014. Operation Sovereign Borders saw migrant boats intercepted, and then those on board were either returned whence they had travelled or taken to immigration detention centres in third countries. There were some 400 illegal boat crossings in 2013, the year the operation was enacted. Within a year, the problem was eliminated. Denmark, between 2015 and 2016, announced a range of measures intended to make their asylum system significantly less attractive as a destination for illegal migration. The result was a reduction in claims from 21,000 in 2015 to 6,000 in 2016 and 1,500 in 2020. For every one asylum seeker that arrived in Denmark in 2021, 3 arrived in Sweden on a per capita basis. So unilateral and bilateral solutions and policies of deterrence can and do work. This is the route the UK has chosen to go down. In 2022, some 12,000 Albanians entered the UK illegally via small boat. In response, we strengthened how we worked with Albania, including improved data sharing, closer operational working, new expedited returns arrangements and financial support. These measures have seen the number of Albanian small boat arrivals fall by 90% so far during 2023. We also work closely with France. Last year, the Prime Minister signed a historic bilateral agreement to deepen our cooperation in combating illegal migration. That included significant investment to increase frontline staffing and policing levels in northern France, better real-time intelligence and data sharing, supported by embedded UK officers, and improved intelligence cooperation to increase disruptions, arrests and prosecutions. This sort of cooperation is necessary, but not sufficient in terms of results. Overall crossings are down more than 20% so far this year, compared with 2022. The system that we are working to deliver through our Legal Migration Act is one that, within the limitations of the broader rights-based framework, says that the only route to asylum in the UK must be a safe and legal route. Anyone who enters the UK illegally will be deemed inadmissible to our asylum system, and following assessment will be detained and swiftly removed to their home country if that's safe, or to a safe third country if not. In 2021, we signed our groundbreaking migration and economic development partnership with Rwanda. Under this agreement, Rwanda will accept physical and legal responsibility for illegal migrants relocated from the UK and look after all their needs while their claims are considered, with a full package to support their integration into Rwandan society. We always knew that our partnership would be challenged in court, and we remain confident that the UK Supreme Court will uphold the legality of the scheme later this year, enabling us to start putting it into operation. While our political opponents, NGOs and others dismissed the partnership as an immoral gimmick when it was first announced, it is striking how many countries run by governments of varying political hues have now expressed in public and in private conversations their support for this model. Many are now pursuing variations of their own. The UK will continue to prioritise policies of deterrence and border hardening alongside the maintenance of safe and legal routes. At the same time, we will look to build consensus for more fundamental reform of the asylum framework at the international level. The goal for reform must be to embed certain principles in the global asylum framework. Deterring illegal migration must be an aim. Countries must have a say in what volume of refugees they are capable of resettling each year. Support and protection should, to the fullest extent possible, be rendered in neighbouring safe countries where it is most efficient to deliver and able to reach those that need it most. The only route to resettlement should be via safe and legal routes. People must claim asylum in the first safe country they reach. The definition of who qualifies for protection must be tightened, and policies of externalisation, such as our partnership with Rwanda, must be recognised as appropriate. I don't accept the false choice between acting unilaterally or even bilaterally to protect one's border and solving this problem through multilateral cooperation. International cooperation is essential if we are to find enduring solutions to the challenges of global migration and deliver an asylum framework fit for the modern age. But nations cannot simply sit on their hands while a reform process plays out. It is right that they act in their national interest. I have, in recent weeks, been meeting with fellow interior ministers in Europe. I will continue doing so in the coming months and hope to bring together partners to a forum where we can begin discussing some of the matters that I've touched on today. Is the Refugee Convention in need of reform? Would a revised global asylum framework work, and how would it look? How can we better balance national rights and human rights so that the latter do not undermine national sovereignty? Could the ECHR be more transparent and accountable in how it interprets human rights and give greater power to nation states to make arguments and present evidence? What are the appropriate criteria for being labelled a refugee these days in the 21st century? How can we stop human rights laws being gamed by smugglers? Are we delivering safe and legal routes in an efficient and effective manner? And while we may have different views as to the solutions, I hope we can at least agree on one thing, that we are living in a new world bound by outdated legal models. It's time that we acknowledge that. Thank you.
Thank you very much for those remarks and for being here to make them. You raised a number of important and complicated questions, and I think maybe the one that's likely to be most provocative is the question of the future of the UN Convention on Refugees. You say it needs to be modernized. Are you saying that if that doesn't happen, the UK may consider withdrawing from that convention?
Well, my personal views on the ECHR have been chronicled and are very clear, but what I think is a legitimate question for all of us to be asking in the UK is whether its operation and its interpretation by the courts is compatible with our pressing need to control our borders and national sovereignty. We've engineered and struck a groundbreaking deal with Rwanda. We believe that to be in compliance with our international obligations and compatible with international law frameworks. We've just passed new legislation in the form of the Illegal Migration Act. We also consider that to be compliant. So we are wanting to work within those frameworks, and we are confident that we can achieve that. But I do think legitimate questions need to be asked about the somewhat ill-fitting nature of how these, as I've said in my speech, outdated international models are sitting with the global migration crisis of the 21st century.
How do you think about how those models have become outdated? The words on the page of the UN Convention have not changed, at least since the one protocol in the late 1960s. And yet, as you say, the practical forms they've taken and the actual practice of dealing with refugees all around the West, all around the world, have changed dramatically. How has that happened, and how would changing the words on the page actually address that problem?
I think a lot of the challenges we face are because of the jurisprudence and interpretation by courts and a more forward-leaning and expansive approach taken by judiciaries around the world. So whether it's in the context of the ECHR, we can see Article 3, which is the prohibition against torture, or Article 8, the right to family and private life, being stretched beyond all recognition to what the original intent of that convention was. In the context of the Refugee Convention, whether it's the definition of refugee, as I set out in my speech, or whether it's the definition and interpretation of refoulement, onward travel, those have both been subject to unforeseen and expansive interpretations by courts, and that jurisprudence and case law has then imposed greater burdens, I would say unsustainable burdens, on governments around the world.
Maybe we can untangle two elements of the way that you describe this in your remarks. The question of national sovereignty on the one hand, and the actual specific content and substance of the treaty commitments. You may know the United States was not an original signatory of the UN Convention on Refugees. The Truman administration in the 50s decided that it was too much of a violation of American sovereignty, and the United States stayed out of the treaty for 17 years until the late 60s. The objection there was a matter of sovereignty. They argued that the treaty would take immigration policy out of the hands of the U.S. government. The argument you're making seems to be more that the specific substance of the multilateral commitment is the problem. You do seem to think that there can be a multilateral way to deal with refugee issues, that there is a way for nations to agree on rules without losing control of their immigration policy. Is that right? You think multilateralism is the way to ultimately frame refugee policy?
I don't think these are mutually exclusive choices. I think there needs to be an international level approach, which is consistent and has an equitable approach instilled throughout it. And that's why I'm calling for a renewed global conversation about the substance of some of these international conventions. And I believe that the nation state, its very concept and existence is dependent on nationally elected governments, which are held to account by the electorate to take their own decisions unilaterally or bilaterally, in the way, for example, that we have done in the UK with our partnership with Rwanda, or defining and rolling out particular and bespoke domestic legislation.
So what is the right definition of refugee? In a sense, you put your finger on the problem that there really are people, many people, who really are endangered, really are in a position that is like the one that these treaties were intended to address. There are also people who are now covered by those definitions that are not in that position. If it were up to you, or if the process you're calling for were to start, what definition of refugee you think would work in the 21st century? Who is a refugee now?
Yeah, well, I mean, again, as I pointed out in my speech, I think the definition has expanded beyond what is a reasonable and sustainable approach. And what we are seeing in the UK, at least, and in the EU, is that economic migrants are falling under the umbrella of refugee, whether through kind of illegitimate claims being made to mask the fact that they are economic migrants or otherwise. And we have seen in our case law and what's been played out in the courts a disproportionate allowance being made for economic migrants under the guise of asylum law. And that line has been blurred. As I've said, people are leaving a safe country like France, coming to the UK and claiming asylum on a prima facie interpretation of the international text. That should not be allowed. But jurisprudence, case law, practice, convention has built up over time to render that not the case. So that's one very simple example of where
a reaffirmation of the existing definition is what would be important.
Yes. I think we do need to review that and look at it in the context of increasing numbers, increasing ease of travel, and pressures on countries.
So you're here to talk about these issues with your American counterparts. You're meeting with the Attorney General and the Secretary of Homeland Security and others. Do you have a sense of how they will respond to this argument? Do you have a sense of the Biden administration's attitude about the need to modernize the refugee arrangements, or in general a sense of their response to the situation they're dealing with at the southern border here?
Well, listen, I value the very good dialogue and relationship operationally that I have with my opposite numbers in the US administration, Secretary Mayorkas and Attorney General Garland. And the UK and the US, we share so many common values, and we're both grappling with this challenge in very similar ways. I'm keen to start this conversation. I have talked about it in other international fora with other international counterparts, and that has been something that's been met with, some level of support. So I hope that we can start amplifying this kind of global level conversation amongst like-minded nations. But listen, I commend Alexandra Mayorkas for the approach that is being taken here in America. For example, agreements with Mexico is very similar to how we've been working with France and with Albania to try and ease the flow. It's an incredibly complex, challenging situation, and it's very difficult to find nations who can declare victory on this problem.
We're going to take a couple of questions here in the room, but before we do that, just maybe one reflection on your own background. As a daughter of immigrants, how does that shape how you approach these kinds of questions? These are obviously intense, contested questions in the UK as much as in the US. What do you think that background brings to the table for you? How do immigrant communities in Britain think about the refugee question at this moment?
Well, I have a somewhat personal experience of migration. My father came to the UK as a very young man. I think he was about 19, 18. He was effectively kicked out from by Kenya in 1968. He always tells me movingly of the cold February morning that he stepped off the plane at Heathrow Airport. No friends, no money, no family, nothing but his British passport. And it was his British passport that was his symbol of hope. And he made his life in the UK, never once went back to Kenya. And I always think about the vulnerability that he must have experienced then. And my mother, she was recruited by the NHS as a girl of 18 in Mauritius. And she came over because the NHS was a symbol of excellence, of opportunity. And she came to contribute to the UK to make a better life. This is post-war in the 1960s. And they both signed up to British values wholeheartedly. They're fiercely proud of Britain, the British Empire. They're from former colonies, and being part of the UK in a full and, you know, energetic way. And they came here lawfully. They came to the UK lawfully, by the rules, occupying their place in the queue. And I think it's informed my view of migration. And what I think angers many people in Britain, whether they are from a migrant background or not, is the sense of unfairness, that people are jumping the queue, that they are breaking our rules, that they are coming here, you know, gaming the system. The sense of unfairness, the sense of injustice, I think, is what you know, really angers people in the UK, myself included.
Let's take a couple of questions in the room. We have just a few minutes. We can start back here. There's a microphone coming your way. Just a moment.
Thank you very much, Home Secretary. I'm Mark Stone. I'm from Sky News. Thank you for doing this. I just wanted to pick up on the anecdote you just gave, a very eloquent anecdote about your father, that he had no friends, no money, no passport. He wanted a better life. Do you accept that that is the story replicated throughout this migration journey? Every single one of those people has the same story that your father had. And I wonder how you could square that with your views that you have outlined this morning. And just to follow up, if I can, some have called your speech here grandstanding, and you can kind of see why. This is a very, very small room in America. You're speaking to a very small audience. And I wonder if this is perhaps more about your leadership ambitions of a party that's really quite struggling at the moment.
Well, addressing the first issue, I mean, what you're suggesting is because I'm the child of immigrants, I have to adopt a position which is pro-migration and pro the status quo. And I totally and fundamentally refute that. I think that is totally at odds with the challenge that we are facing today. Unprecedented levels of people coming to our country illegally with no right to be there, gaming our system, pretending to be refugee, pretending to be fleeing persecution, to come to the country illegitimately. And I mean, that cannot be how we conduct this conversation. We need to be honest with the British people, and we need to be honest about the challenges and the solutions. And just because I have an immigrant background does not exclude me from this conversation. And my job as Home Secretary is to be honest with the British people, to tell them that the system as it currently stands internationally is not working. We need to start working towards a solution that is sustainable and fair. Listen, I'm incredibly honoured to be here at the AEI. The AEI represents the forefront of thought leadership and policy making in the US and actually internationally. And to be hosted here to talk about migration in the international context, followed by meetings with my American counterparts, is really, again, part of my day job, part of my duty as Home Secretary. I want to lead this conversation globally, and I want to work with like-minded partners to find a solution.
Let's take one last question if we can, right over here at the end.
Thank you, Home Secretary. Tony Diver from the Daily Telegraph. Can I ask, If you don't agree with the UN Refugee Convention as it is, but you accepted in your speech that it's incredibly difficult to reform because of the number of signatories, can I ask, would you consider leaving the convention altogether if it is too difficult to reform? And just a short follow-up, with the Rwanda policy held up in court as it is, I know you discussed that as well, can I ask you how realistic you think it is that the government will still be able to reach the Prime Minister's pledge of stopping the boats by the next election?
Listen, just because multilateral negotiations are difficult, it's not a reason not to engage with international partners who are grappling with similar challenges and asking elemental questions about whether the frameworks are fit for purpose. And so I am seeking to build a consensus internationally. And ultimately, the Prime Minister himself has said, we'll do whatever it takes to stop the boats. And that's my position. And that illustrates the resolve, the intent and the commitment of the UK government to fix this problem, whatever is required. The second question was about...
how realistic do you think it is that the boats will be stopped? The Prime Minister seems to be less confident than he once was.
Listen, I mean, we've made progress this year. We've passed the largest piece of legislation, the largest changes, set of reforms to our migration laws in a decade. We've passed our Illegal Migration Act. Many people said we wouldn't be able to get that enacted, and we achieved that goal earlier this year. We are now awaiting the decision, the hearing and the decision of the Supreme Court on our Rwanda agreement. I'm confident in the lawfulness of our agreement. I'm reassured by the fact that the Lord Chief Justice, the most senior judge outside the Supreme Court, found in the government's favour, the High Court found in the government's favour, and I hope that if we are successful in the Supreme Court, we will be in a position to operationalise flights to enable people to be removed and relocated to Rwanda as soon as possible thereafter.
Well, that's our time. Suella Braverman, Britain's Home Secretary, thank you very much for being with us.
Thank you.